Blessed be the name of the Lord God, to whom all mercy and honor is due. In the name of Almighty God, the omniscient, the benevolent, I greet you in the Arabic words of peace be upon you. Salam alaikum. With me here, ladies and gentlemen, I have a distinguished scholar, a man of no simple credentials, a man who has distinguished himself in the legal fraternity, a friend of almost every individual you can tell who has a mark on this nation. I got to know this gentleman through my interface with him in certain alma maters where we do teach law. This man has distinguished himself as an author, but also as an intellectual in issues to do with Islam, but also legal jurisprudence. He thrives in doing a lot of moonlighting, first of all, as a proud dean of Guru Faculty of Law, but also a lecturer of Faculty of Law, IU, and also a dean of deans. So he's none other than Professor Dr. Shadat Semakula. Professor, you're welcome today on this wonderful show where we demystify the law.
Viewers, I salute you, the best salvation shown by Allah. May mercy and blessing for Allah be bestowed upon everybody. And I send my condolences to the family of the profound Justice Arach Amoke, who was my friend. And also may God protect the family, because we know there is some conundrum surrounding the burial of Amoke. But I know if we remember the case of Mukeo and the case of Kasango, we know that it is better a person to be buried at the ancestral home. That has been the culture. I hope that the family will be protected, and also the two families will dialogue to see that our profound justice of Supreme Court, Arachi Amoke, gets a decent send-off.
Okay, right, Professor. I want you to take me through some of the debates that the country has been held on their toes for some time, specifically the one that has to do with your friend, I'm sure you know him, Hamis Chigundu, who I'm reliably informed is also a lawyer. What, in the interest of jurisprudence, are some of the propositions that are facing this particular challenge as far as the case of Hamis Chigundu?
The issue of Hamis Chigundu is very simple. Hamis Chigundu, we know summary that she checked his account in 2019 and he found that the money is being taken out of his account, around 129 billion. So he called his auditors to go and check, and also he called DTB to reconcile the differences. Upon that, then he commenced proceedings to court. We know that the first ruling, which was before Justice Adonyo, amidst competition, and said that DTB did not have a license in Uganda and all the transactions were illegal. So the case went up to Court of Appeal, where also Court of Appeal reversed or disagreed with the decision of the High Court. So today, as an academic, is to examine the conundrum and the legal gymnastics surrounding the Ham case. We shall be looking at some factors that we can then, after the factors, we shall find out whether indeed the ruling was okay or not of the Supreme Court. The first question would ask whether harm, when you look at the facts of harm, we are going to look at some of the issues. First, we shall look at why, whether the contract of harm had what we call exclusive clauses, or what we call non-convenience clauses, or non-exclusive jurisdiction. Because we have to determine, did the High Court, did the Court of Appeal, Supreme Court, have jurisdiction, first the High Court, did they have the jurisdiction to hear the matter before it is appealed? In that way, when you look at the contract of harm, they did not specify or provide exclusive jurisdiction, because there is what called clauses for jurisdiction and clauses for the law. When you look at, in the case of Dutch Bank against Sebastian Holdings, you would see that when they are contract and they have got exclusive jurisdiction, the court would make sure that the jurisdiction of the contract is where the case is determined. And when you look at the facts of harm, it is not provided. Neither do you find the clause of what I call non-convenience exclusion clause, which provides that because of some problems, we cannot have a jurisdiction in that country. Or the other one would be what I call non-exclusive jurisdiction. This one provides that you can have anywhere your case. So in that way, you could see and say on that position, the court having found that there was nothing to clear, they have to come up with a formula. And the formula they found is to see that the intentions of the parties are enforced. And that's how the court ended up trying to avoid prior proceedings, and the judge had to find out, to find the intentions of the parties. The intentions of the parties, you see harm and DTB. And when you look at the intentions of the parties, you would find that to determine the intentions of the parties, the court should also have considered what I call private law or public international law, because that one will determine even the forum. This was more decided in the case of Mountain Albert against Australian Insurance, where the court said that if you can't find the clear clauses of the contract, then you can go to what we call private law, or what I call conflict of laws, which is provided in the case of Desai, Morrison, and Collins, conflict of laws. So in that analysis, the court, after failing on that, we can also analyze 6 factors. 1, the lender was Kenyan. The loan contract was made in Kenya. The location of the debt was in Kenya. The mortgage property and registration of securities was in Uganda. The collection agent was in Uganda. The borrower was in Uganda. The currency of the loan was a dollar. The language of the contract was English. In absence of contrary evidence, the law governing the loan or credit facility is the law of the place where credit is extended or the loan is availed. In that way, the court considered that commencing proceedings in Uganda was okay. And the other question would also look, another factor, is what I call the economic social development of the country. This should be done by repeating the commercial contract, and this is done by repeating the intentions of the parties to the contract, and also where there is an express choice of the court in that way. So when you consider that, the court had to look into the commercial contract, and in that way they had to proceed in order to see that the contract of the parties is implemented. So the court had to avoid the technicalities of the so-called saga, whether commencing commercial, where DTP working in Uganda or having commercial transaction was okay. So the court had to make that analysis. However, the court should also have considered cases like a Balfour against Balfour, the high priest case, that the intentions of the parties are more protected when the courts are enforcing contracts, especially the intentions of the parties, which in that case, I'm sure, is the reason why the case was tried up to Supreme Court.
Okay.
Then you go to another argument, which is more discussed, what I define as the public policy, which would be the saga, the main issue, whether indeed a financial institution with no license can get back their loan. This was more discussed in banking in the famous case of United Dominion Trust against Kiko, where 1960 2 Queen Bench Division, where it was said that a bank is at liberty to get back their loan, and the technicalities of license should not be a matter. It is a question of enforcing a contract obligation between the parties.
Okay.
And that is the position why in Uganda the issue of license was not so much looked at under public policy. Because under public policy, it is not an individual to bring a regulation. It is the power of the regulator to enforce that obligation, as was discussed in the case of United City Merchants against Royal Bank of Canada. They said it is the regulator under public policy to enforce a breach, not an individual as harm. That is something that they should also analyze on issues of public policy. We know in equity, equity cannot benefit from the wrong. Once there is a wrong, you cannot use the public policy for any illegality. So there, in the case of Stevens against Tony, where it was affirmed by the insurance company that a court will not assist a claimant to recover benefit from a wrong. We know everybody that in equity, who comes to equity comes with the clean lands. Are clear? Now the question is, was Ham clean? She got the loan in Kenya. Are clear? And having got the loan in Kenya, was he clean to bring a proceeding in the courts of Uganda, especially the Supreme Court, appealing the decision of Court of Appeal? There, when you look at equity, Ham was wrong. We can also look at the case, because we know, when we look at the case of Rebona against Tan, Phipps against Bodman, these cases avoid unjust enrichment. There is a classical case of unjust enrichment. You get $10 million in Kenya, you use that money, and then you don't want to pay back the loan of that loan.
Professor, let us place the discussion into context. When you say that Ham was wrong because he is taking benefit of money from what? Another jurisdiction?
Yes.
And the claim is coming from another jurisdiction? Perhaps, maybe for purposes of laying ground on what we are discussing, one thing we must understand from the word go is that the case originated from what they call syndicated banking agreement between Ham Enterprises Limited and Kiggs International Limited. The two banks, basically, and that was way back in October 2020. So the commercial court judge then, Henry Peter Odonyo, ruled in favor of Chigundu, ordering DTB Uganda to refund all the funds deducted from his accounts. And it was alleged that these deductions were made without Mr. Kidundu's consent. So the records before court actually showed that Kidundu had actually obtained loans totaling to about 120 billion from DTB Uganda and DTB Kenya between 2011 and 2016 to finance his real estate business. So the dispute rose when the banks claimed that Kidundu had actually failed to pay his full loan obligations, amounting to about 39 billion as per agreed the terms. So they threatened to seize the property, and Kidundu petitioned commercial court, arguing that they had actually withdrawn excessive funds from his what? From his accounts, and he had actually repaid. So represented by my friend, Counsel Fred Muema, the businessman actually sought to strike the bank's defense and obtain an order to refund the unlawful obtained funds. And his lordship Adonio dismissed the bank's defense and directed them to refund the money along with 8% interest rate to the cost of the suit. This obviously displeased with the decision. The bank sought to relief from the judge, that is the principal judge, Dr. Flavian Zeja, who actually granted an order of stay of execution of his lordship Adonio's order. And this prevented Kidundu from recovering the funds. Subsequently, the banks appealed to the Court of Appeal. And in the subsequent ruling, the Court of Appeal actually overturned Odonio's order and ordered for a trial before a different judge and dismissed it with this decision, basically. So Kidundu lodged appeal with the Supreme Court. So what happened at the Supreme Court, that is where we are now. We now see another challenge at the Supreme Court, and the Supreme Court has actually pronounced its case or its issues in aspects to do with what I wanted my friend and learned counsel, but professor at the same time, to help us distinguish because it appears the Supreme Court made distinctions in terms of what they call syndicate banking and agency banking, because they are saying there are two banks. In other words, the Supreme Court was not really engaging into the substantialities of the matter, but into procedural irregularities, whether or not these courts were actually had sufficient locus to try these particular matters. And when you're arguing in terms of syndicate banking, what is syndicate banking? Syndicate banking basically refers to collaboration or partnership among multiple banks or financial institutions to provide for financial services to a larger borrower. And this is basically, in this kind of model, the group of lenders known as syndicates jointly fund a loan or credit facility to the borrower. So Supreme Court is now making this interpretation that it is okay for banks to have what they call syndicate transactions, which I don't know whether you're saying that you're finding a fault with, Professor. I would like us to move from that angle onwards. Yes.
You talked about syndicate trading. When look at the issues of harm, the question is whether there was a syndicated loan. One where, because we know that there to be a syndicated loan, it is where two or more financial institutions offer a loan to a borrower, or one group of a located borrower. And then we have, when in syndicate, we have what is primary and direct. Primary or direct syndicate is where a lender makes the initial loan and then transfers the loan or the portion in the loan to other lenders, in which case it is a secondary syndicate. So let me make this one more known. Syndicate in simple is whereby banks can be together, or one bank can give a loan, or two banks can join together to give a loan to a lender. In this position of harm, we are seeing, the question is, because the case is not very clear, because they are saying syndicate. The question is, was it primary syndicate or primary syndicate, or was it a bilateral loan? When you look at what we call as primary syndicate, is whereby one bank borrows one lender. Secondly, syndicate is whereby you borrow money and then you lend other banks. The other one is what we call bilateral loan. One lender, one borrower. So in analysis of harm, you would see that harm had a bilateral loan. Right, clear? Now the question would be whether harm could have that, the issue of syndicate was illegal or not, isn't it? Mm-hmm. Now when you look at the issues of the gymnastic, if the court has ruled that the syndicate was what? Was illegal, isn't it?
That's right.
Now, you would look at the facts of the case. And when you look at the facts of the case, which the judge did not examine, the judge would have gone through the threshold of types of syndicate and then come to the conclusion and say this is a bilateral loan, which something lacked into the judgment. Clear? However, you would also ask, for example, in the case of Saving Bank of Victoria, where the issue of syndicate was also discussed. And they say we have been in history where we are paying by letter of credit and international trade. And banks have been corresponding in one another in order to initiate such. And the good thing with the harm, we know very well, as I gave the other facts, that the escrow account was put in Uganda, isn't it? The mortgage was put in Uganda. The person who the lender is in Uganda. Clear? So when you look at all those facts, there is a genuine mechanism that the court considered this was the intentions of the parties to carry out on business, and Ham owed the duty of care to make sure he pays the loan. Why? Ham was at liberty to go and pay that money in Kenya every week, isn't it? If he did not want to pay at escrow account, which was part of the agreement, should even be at liberty to pay the money in Kenya, isn't it? Which he failed. Clear. So the court could not allow those technicalities. Why? Uganda would be seen as a destination for theft, dishonesty, and subject to breach of contract. And also banks depend on syndicate. That one will make many of the banks corrupt because banks depend on one another.
Sure.
So if you are allowed the illegality and say syndicate is wrong, most of the banks like DFC, Abusa Bank and others, that's how they survive. So they looked at also the social and the economical factor of banking. And if they allowed this, the economy in Uganda was going to shrink. That was another issue to avoid floodgates that might rise. So the court took that position.
So the biggest challenge, as we see, I think, as far as the Supreme Court, was the issue of illegality. I think they're trying to sort out whether or not there was illegality. That's when you brought in the aspect of equity.
Yes.
And we are arguing here in the lead judgment propounded by Justice Afonso Owinyo-Dolo, addressed the sticking issue of syndicated credit facility executed between DTB Kenya and HAM as lawful. So that issue of illegality has actually been resolved now, as far as the Supreme Court is concerned. And now they send the matter back to where? To the High Court for purposes of going back to square one. Now, if you are arguing things to do with the different types of syndicates, for example, syndicate banking can be classified into different types. For example, we have what we call acquisition financing syndication, where this type of syndicate involves providing funds to finance mergers and even acquisitions. We've got what we call project financing syndication, and then this basically this involves providing funds for large-scale infrastructure projects. And then we have got what we call leverage banking syndicate, which basically also involves some kind of providing finance companies with high levels of debt for purposes of leverage. And then real estate syndication, and also international syndication, and also revolving credit facility syndication. So the question of debate here is no longer an aspect of syndication or not. That court has pronounced itself on that, because like you rightly said, banks depend on one another in terms of commercial transactions and exchange of monies, or even helping other facilities where a bank may not have all the money but can actually go and get money from another bank where they have those relationships. So, going back to square one, are we faulting Mr. Chigundu that he has refused to pay the money? Professor?
In fact, before to say that did not, I think the court also erred. They would have also considered East African community. We know the provisions of this African community is the free movement of services and labor, clear, and banks are services. But the court did not pronounce also in East Africa. I think the court, the Supreme Court, owed the duty to also clarify on the issue of because many have argued that Uganda is an independent state. And why should it be bound by foreigners? They see Kenya as a foreigner. But me, I see Kenya within the framework of East African community. And we know the highest appellate court here is East African Court of Justice. So now, the court should also have pronounced on the free movement of services within East African community, because Kenya is a member of East African community. And the convention has been ratified between Kenya and other countries and members of East Africa. I think the court would have looked at that. Also, the Supreme Court would have looked at what we call the doctrine of proportionality. That in achieving any legitimate aim should be proportionate and legitimate. Now you could see that Ham went to court, but by him refusing to pay back that money, it is not proportionate and it is not legitimate, because you cannot hide under the technicality of license for refusal to pay back. Equity cannot support that illegality, because we know very much that illegality, harm can rely on illegality to wiggle out its contract obligation. He had at liberty to rescind the contract. We know very well that under the section 55 of the Contract Act, when you know the contract is void, you just what? Move out. That is also another way of restitution. But Ham used the money, doesn't want to pay back. We also know that the court should have analyzed the Supreme Court, what I call quiz close trust. What do I mean? Is money where you have put securities and it was for purpose. Are you clear? By a person putting in these securities, he knows the purpose of that loan. And the law says, if you don't use that money for that purpose, you return that money back. It was discussed in the case of quiz close trust against Barclays Bank. So, when you look at that, we see that Ham should have followed those procedures. And the court refused to even pronounce on those factors. I think the Supreme Court would have done. Now the irony you have mentioned, by allowing this case to go back to High Court, it is going to bring a conundrum. Why? The High Court is put at a test because some of the issues that they would have addressed, some of the technical issues have been addressed by courts, Court of Appeal and Supreme Court. It would have been prudent for the Supreme Court to summarize and make a final ruling on this matter because we are seeing to and fro. And now, given the doctrine of theodicies, how is the High Court going to determine a matter whereby Court of Appeal has overturned, almost the Supreme Court has technically overturned? Why was this matter being turned to High Court? I know High Court has unlimited jurisdiction under Article 139, but when you look at that, I don't see any changes. It is more of a political legal gymnastics.
Wow, there you go. There you had the man. But predominantly, I think what we are all agreeing here in as far as Hamis Chigundu versus Diamond Trust Bank and Kenya, Ham versus DTB, we have to understand that it is issues that have to do with where courts are pronouncing themselves and they're arguing that an illegality once brought to the attention of court cannot be allowed to stand. And I think the authority there is Makula International Limited, which you look at also Cardinal Lubogo and Reverend Father Cheine, each of their representative capacity. You look at that case also will bring you in terms of a discourse. But as we have argued here, we have established that there was a relationship that has been created between Mr. Chigundu by virtue of the fact that he was a long-time client of Diamond Trust Bank. Diamond Trust Bank sought to borrow excess money from another bank in Kenya, which is allowed by way of syndicate, as we argued, so that is no longer a question of contention. Perhaps the bigger question now is whether or not Mr. Chigundu ought to or needs to fulfill his obligation. But he has argued that the money was paid and these guys were actually sucking more than what was, required of him. And that's why he actually went all the way up to the Supreme Court. But it is interesting that now, as we have identified that now we're back on square one. Square one has opened up a can of worms, a conundrum, to use my brother's words, in terms of other dispositions that the law would have to pronounce themselves. Let us watch and see. As that, would you like to say something in conclusion?
I think in this case, the best way we have, as a scholar of international arbitration and mediation, it would be prudent for Mwema, the lawyer, to sit with DTB, Kenya, and DTB, which is a scholar account for Uganda, to relay their issues where dialogue would be better to avoid the media crisis, which that economic hysteria ignites the social and political barometer. We could, if these two could meet and mediate, maybe in Kenya, whatever they argue, I think they can come to a better standard. And because if they do, Ham would be in a better position to pay the money. They can get more time. They can also reduce on the principal interest. Some of the sureties that had been put, they could also discuss which sureties could be taken. And also Ham has used this money, because when you use this money for a long time, because from 2017 today, that money has been invested. Ham should also be honest to say, okay, given also that time we had Corona, we had COVID, the economic factors were completely down. Everything was dead, economically, globally, and I could not make any business. And now that way, they are coming to a real sense of dialogue, of mediating. Are you clear? Yes. By discussing the COVID saga, the global climate on business, China was closed completely, Uganda was closed completely, Ham has got buildings where people have not been paying at all because of COVID. The economy completely is very poor.
So you are saying,
that time,
yes,
Ham should, the lawyer Mwema, should address this COVID saga. So the COVID saga and the way the commercial industry is working, is not in favor.
Right.
So on that position, they could now discuss on the repayments. Because the position, we would argue with Ham if Ham was discussing on issues of whether the interest is proportionate. That would agree with him. But what we don't agree is taking the money and you are hiding under the technical issues of license. You knew very well when you are taking this money that you should take the money back. And for us, we are saying you come to court with the clean hands. So that way, you have now known that the courts have said there is a case of the matter. The best way, you sit down in mediation. And when you sit in mediation, we have people like Justice Chiragwe in Court of Appeal and others. You can have a panel. And I'm sure this case would be better resolved through mediation.
Right.
So that East African community could be seen as one entity for prosperity, social and economic development.
So you're arguing, Professor, that perhaps Ham and his entourage here are arguing issues to do with technicalities.
Yes.
Is that right?
Yes.
And by virtue of Article 126, 2A, substantive justice shall be administered without undue regard to what? To technicalities. So
even
here,
126.
yes. So here we're arguing that Mr. Ham Chigundu ought to definitely took benefit of the money. And you are arguing that perhaps the escape route would be to provide substantive reasons to the reflection of the fact that this was COVID times and therefore there were challenges.
Yes, and the other thing,
yes.
from Mr. Council Lubogo,
yes,
the issue that has been raised by Mwema and other people, that Uganda is a sovereign state, and then also that courts should not make a law by allowing syndicate, they are making the law. No, people should understand that judges, through interpretation of international conventions and also issues of letters of credit and also other cases international which they refer to, like in the case of 7 against Besigye, they refer to international political rights, they refer to Universal Declaration of Human Rights. By referring to such conventions, they are also trying to make the law, because they look at the purpose, the preamble of the law, and through that they try to take away the mischief. Like now in this case, they are trying to take away the mischief in order to promote East African community. And we know we are trying to promote East African commercial entity. Yes.
And there is no doubt, as Supreme Court pronounced itself, that syndicate backing is legal. And perhaps the bigger question now is, where does it leave Ham and his entourage? But like you have later provided, ADR is a probable option. So I think it's time now that every person faces their music, as it were. That has been episode 1 with my friend, distinguished professor of law, my brother and friend, Sheikh Ohaji. Zamakula Shadat. God bless you.
Eid Mubarak is very important.
God bless you. That's episode 1.
On 28th June, we are having Eid Adha. We are slaughtering animals in remembrance of Prophet Ibrahim, who was bound to slaughter his son Ismail. So this is a day of remembrance, and it is this month that Muslims will be assembling in one of the longest and biggest place in Saudi Arabia, which they will be making sure that they become Haji. And we have a lot of our pilgrimage have already left in Mecca. May Allah bless them so that they finish their Hajj and come back full as Hajj and Hajjat. And that is something that I salute the nation to know that on 28th of June is a public holiday. You are free to join us as Muslims in Uganda to celebrate this magnificent day of Eid Adha.
Okay, in episode 2, as a continuation, in the interest of time, because we thought we'd have a break, but let's blend it together. Professor is such a rare individual to get hold of. So it's, when you get the opportunity, you have to make sure that he speaks everything that is on his heart. I would like him to address us in a very, very important and pertinent issue that has to do with a topic that I'm writing a book about, which is called, I have a book that is coming out very soon called The Illusion of Blame, Untangling the Web of Stigmatized Prejudice unveiling betrayal, scapegoating, and the hidden realities faced by innocent Muslims. How many times have we seen in this world where victimization of Muslims has taken place? Even when rebel groups go into rebels and become, bush warriors, they tend to change their names from their right names to other names of Islamic or, Arabic origin. And we have seen instances where every kind of terror or every suspicion of a bomb arousal is directly inflicted and, chosen to be done by these particular individuals. Where is the line? Where is the drawing line, Professor?
Thank you very much, and the viewers. The use of Islamophobia, terrorism, and the way the Muslims have become second generation in Uganda is a contentious debate. First and foremost, Islam provides that Assalamu alaikum, which means that peace and mercy of God be bestowed by everybody. That one also indicates that Islam is about promoting peace. So let me also look at the international perspective. When I look at the freedom of worship in the American Amendment of 1791 and the Bill of Rights, all provided for the freedom of worship. The European Union and freedom of religion are inculcated into the Universal Declaration of Human Rights. The European Convention also provided for the same. So we ask the question on the issue of doctrine of proportionality, whether the Muslims are handled proportionate like any other people. We know that even the Council of Europe, which was set up in 1949, with the aim to promote religiosity after the Second World War, and we know that after that, the European Convention on Human Rights in 1950 was ratified, which came into place in 1953. The question is, all the West have agreed on the rights of individuals, including Muslims. We know that the right of a person not to be degraded or put into slavery is an absolute right, not a qualified one, under the European Convention for Human Rights. We also know that the Universal Declaration of Human Rights, Article 18, eliminates discrimination on religion. We all know that African Charter on Human and People's Rights also avoids or forbids violation and discrimination subject to religion. We are now seeing the UN Convention on all sorts of racial discrimination, the United Nations Convention on Civil and Political Rights, and the protocols of the UN, the Convention on Elimination of Discrimination Against Women, the Convention on Against of Torture and Degradation and Punishment, the Convention on the Rights of Children, the Convention on Forced Disappearance. All these ratifications, Uganda is a member. And we know that the Commission on Human Rights in Geneva has also spoken about this. Ugandans, Muslims are citizens of Uganda. The Constitution of Uganda was inculcated the Human Rights Commission to investigate atrocities, abuse of human rights. The Muslims have become a continuous phenomenon of elimination, degradation, and taken as second-class citizens. I call upon the Parliament of Uganda. You talk about other cases. We supported the gay bill, the LGBT. I gave commentaries on the LGBT. Honorable Basaru joined the Uganda forces fighting LGBT. It is time we call all other religious sectors to join the Muslim community to avoid this stampede, this barbaric way where younger boys were beaten down at the place of Sheikh Kamoga. Sheikh Kamoga is around 80 years. That place is registered. People have been taking children there who have become rebellious to be modeled in a way on Islamic jurisprudence and culture. Sheikh Kamoga gets letters from the RCs. He gets letters from the parents. The parents bring these children in order to avoid gangism in Uganda. Now, if you fight such a religious center, you would be also fighting gay. You'd be the people being gay in Uganda. Because if these younger children do not grow up with a moral fiber on moral grounds, they would not know the difference between a man and a woman. I call upon the government to also implement Article 21, which avoids all forms of discrimination. There is a chapter on human rights in the Constitution. Muslims have been killed. We know the sheikhs that have been killed. Among them, Chiria, others have been assassinated. There is one who has just been assassinated in Jinja recently. And also, not only even the Muslims, I also condemn other Ugandans that have been killed arbitrarily. Muslims live in Uganda. Islam came in Uganda in 1830. Christianity came in Uganda 1777 and 1779 by Brother Hamans and White Fathers. Islam is the first religion to come. And it is on record that in Namugongo, the highest number of martyrdom, around 200 Muslims were butchered. The Christians around 20. We suffer in the same agony. It is high time the second definition of Muslims should abort. I know during colonialism, Muslims were never allowed to study. Muslims were second-hand definition. The 1900 Buganda Agreement, we never got any land. But now, by 1988, I salute the government by allowing the enactment of Islamic University in Uganda, which has been a roadmap of the election or a champion of education in Uganda. Many Muslims are now educated. We are professors. I'm now the dean of the government university. We have so many Muslims. Justice Sakan is a Muslim in court. We have Justice Nyans. Colonialists fought Muslims. I salute this government that much as there are some shortfalls, at least the liberty, the civil liberties of Muslims to gain education has been granted. We also ask for more protection. We are very good citizen abiders. What we ask for one thing. When I have committed a sin as Muhammad Sadat, let me be called as Sadat, not as a Muslim. When Kony made a lot of killing, the assassination in northern Uganda, we never called all the Christians as terrorists. Let us also be treated the same, that when you commit a sin as a Muslim, it is not the Muslims. Stop attaching Muslims to any criminality done by one Muslim. Islam is about peace. And I salute you in the best salutation if this message is taken by the head of state, security organs, and all other sister agencies. And we also ask the Intelligence Council to come up and condemn what happened at the residence of Sheikh Yunus Kamoga, who is an elder in this country, who is a sheikh in this country, is a leader in this country. We need peace together.
Okay. Professor has ably said it's not right for us to practice Islamophobia. It's incorrect. I think Dr. King used to say that black supremacy is as dangerous as white supremacy. So this ideology of victimizing particular people or a religion on the basis of their religion shouldn't be seen, and thank God that the Constitution of Uganda does not condone that. And all the professor was saying, to use his words, is that we are brothers in spite of our differences. We are inextricably bound, to use Dr. King's words. We are woven together. He said, I cannot be what I am until you are what you are. In other words, I have to be your brother's keeper, your mother's friend, your sister or your brother. We are all one family. That also makes a very pertinent point in another book that we're writing called Shadows of Silence, and which we call Unsolved Cold Murders in Uganda. We have so many unsolved cold murders that have happened in this country, where
Muslims.
and like rightly said, quite a number of different people, high class, military officers, and many times we have even engaged people like Scotland Yard to come and help us do these forensic studies. Today I was at an institution where they're actually trying to do cybersecurity and forensic studies, strategic studies, which I thought was very pertinent for this country. I know we have a forensic department in the police unit, but it's high time. We have also a university now, I'm told, in Ginger, where they're now going to start teaching forensics. So these are important subjects for you and I to embrace. But bottom line is, we are brothers. In conclusion, Professor, what do you say to our audience?
To the audience, let me make this one very clear. There are people using Arabic terminologies, using Arabic names. Islam is defined by character. Let me give an example. When Umar bin Khattab conquered the Byzantine Empire, he ordered the Muslims to clean around the church. And the Muslims asked him one question: why should we clean around the church? He said, you construct your mosque far away from the church. And they also asked why. He said, Islam is about character. So our character is very important. It is seen when we are in Abyssinia in 622, Muslims are very good. The irony are people using Islam as a blanket to destroy the image of Islam. We know that when NRM came to power, Super Minister Mbabas used the name of Muhammad Imboya. These names, when you hear Muhammad Imboya, you thought is a Muslim. Shaban Bantarize is not a Muslim. General Salim Saleh is not a Muslim. The president was called Ahmed, was not a Muslim. So understand that when you hear the name Arabic, Arabic is a language. Distinguish between the character. There are so many people, even at times, I condemn the assassination of children in Chikamba. Even I also condemn the killing in Kasese. Whether it is done by Muslim, Islam is against that. There is what we call Khawarijites in Islam. Is a person hiding under religion and he commits atrocities. For example, Lord Resistance Army. What Lord Resistance provides by killing is not provided by the Ten Commandments in the Bible.
Right.
We should also understand that what Jamil Mukul did is anti-Islamic, and we define him as a Khawarijite. A Khawarijite is a hypocrite using the religion for his political gain, but is using the religion to taint the image of Islam. Wow. So you should also understand that. Wow. In that way, let me make my synopsis by wishing you the best. Peace and mercy be bestowed upon you until the day of reckoning.
So my friends, in the name of Allah, the Merciful, the Beneficent, using the Arabic words of peace be upon you, Assalamu alaikum. We're all brothers in unity. We're all brothers on this planet. Let's practice Ubuntu Wolamu. We are all brothers. So in unity, we forever conquer. Thank you and God bless you.